A Trump-appointed Texas judge has struck down President Biden's student loan forgiveness program, meaning that unless something is done in January, 46 million people will begin having to pay the entirety of their loans with no forgiveness. So they'll have to restart their payments. Now, U.S. District Judge Mark T. Pittman on Thursday declared Biden's policy of forgiving debt under the 2003 HEROES Act to be unlawful. The DOJ is saying that the act grants the Secretary of Education, and not just the DOJ, but the law as well. It grants the Secretary of Education authority to reduce or eliminate the obligation to repay the principal balance of federal student loans, including on a class-wide basis. Now, you can do that under several different, ways. One of them is under an emergency, which COVID was. So in a national emergency, the Secretary of Education can say, okay, you don't have to pay your loans. So that said, in this ruling brought by a conservative group, in a lawsuit brought by a conservative group called the Job Creators Network, of course, in this country, we are not ruled by an all-powerful executive with a pen and a phone, Pittman wrote in his order. Instead, we are ruled by a constitution that provides for three distinct and independent branches of government. The Job Creators Network Foundation had filed this lawsuit back in October on behalf of a borrower that does not qualify for the full $20,000 in debt relief and one who is completely ineligible. I will give you their stories and why what they're doing is absolute yes. But first, the suit alleges that the administration had violated federal procedure by denying borrowers the opportunity to provide a public comment before unveiling the program. In the Texas case, the plaintiffs argued in part as well, the Biden administration made arbitrary decisions about who would qualify for debt forgiveness and how much of their balance would be canceled. Biden's loan relief plan cancels up to $10,000 for borrowers who earn up to $125,000 annually, or up to $250,000 for married couples. Borrowers who receive Pell Grants are eligible for an additional $10,000. One of the plaintiffs, Alexander Taylor, falls under the income threshold and is eligible to have $10,000. However, he did not have a Pell Grant and therefore not eligible for the additional $10,000. And so he's saying, well, if I don't get the extra $10,000, then nobody gets it. Oh, great. Wonderful. Now, the other one, Myra Brown, she is ineligible for Biden's plan because her federal loans had actually originated through the defunct Federal Family Education Loan Program, which is held by private banks, private entities. And until late September, commercial FFEL borrowers like Brown could consolidate their loans, but she decided not to do so, into a direct loan that could become eligible under Biden's plan. However, as a result of 6 Republican states that have sued, the Education Department had to reverse the policy. Oh, so again, I didn't get this. Therefore, no one shall get it. Well, I've got a solution for that. You just cancel all student loans. That's what I was saying from the beginning. Yes. Why not just make it universal? Well, look, this is, again, while in favor of all cancellation, when you do something universal, it takes away these arguments. Simple as that. And by the way, this is also applicable to all means-tested programs. Look, Social Security and Medicare, they're not means-tested, all right? And guess what? They're the most popular programs in the country. Makes it very, very difficult for Republicans to get rid of it. Once you're 65, you get it. Now, that said, I think Republicans haven't tried to cut it. Ron Johnson literally is going to try to cut it. But it's harder to do because it's a universal program. Republicans love Social Security and Medicare. And if you actually tell them, hey, this politician's going to cut your Medicare and Social Security, then obviously they're going to vote to protect it, to actually protect it. But that said, before I get to the administration's response to this, because they have responded, I want to go to a report in The Intercept by Ken Klippenstein. So, and this is about the people that have filed the suit, as well as the judge's political connections, and why maybe he shouldn't be presiding over this case. Now, Klippenstein writes that Myra Brown, well, she's not happy that she didn't get her private loan discharged through this because that program, of course, never promised to discharge that private loans. He writes this: Brown, one of two plaintiffs in the Texas lawsuit, owns Desert Star Enterprises, Inc. Desert Star, which appears to be a sign-making business, was granted a $48,000 loan, of which $47,996 was forgiven on April 27, 2022. So, wait, again, she's mad that she didn't get her loans forgiven for student loans, the $20,000, but she actually ended up getting $47,996 forgiven when it comes to Paycheck protection. Huh. Interesting. Now, The Intercept contacted Brown for comment. She responded via text message with a picture of a printout reading, "We have no comment," and directed any inquiries to the Job Creators Network, a conservative advocacy organization bankrolling the lawsuit. The Job Creators Network, by the way, founded by the CEO of Home Depot and funded by the conservative Mercer Family Foundation. Elaine Parker, president of the Job Creators Network, also talked to The Intercept, saying the Paycheck Protection Program is not comparable to Biden's bailout. Congress passed PPP, making it a federal program. Biden bypassed Congress, making it illegal. PPP was an emergency measure to help small businesses survive government-imposed lockdowns. PPP was always designed to be forgiven if certain parameters were met. Except there was no enforcement of those parameters. I've got examples here. You had corporations that were given PPP loans that still fired workers and pocketed the money. According to a study published by top economists at the National Bureau of Economic Research, they found that the distribution, of the $800 billion of PPP money, less than 35% went to workers. The rest of the money, a full 2/3 to 3/4 at most, went into the pockets of either the company's owners or the shareholders. They also found that the distribution was highly regressive because it overwhelmingly accrued to high-income households. According to their paper, 72% of the funds from Paycheck Protection flowed to the top 1/5 of all households by income, even though, statistically speaking, nationwide, this group accounts for just 35% of earnings. So now this is interesting. So most of the money from Paycheck Protection didn't go to the workers, it went to the rich. What is the argument that conservatives are using against student loan forgiveness? Oh, right, that it's most of the money is going to benefit the rich. Do you remember that argument? I do. And by the way, corporate Democrats were also using that argument against Biden's plan. Was it not Tim Ryan that said that was mad that this student loan relief would supposedly go to well-off college graduates? Interesting. Again, it doesn't. The debt relief actually goes to a lot of middle-class families and mainly Black borrowers. That's where the relief is going. It's almost like this entire thing is backwards. And they just hate poor people. But there's more. Klippenstein's report also noted that the Job Creators Network, one of their top funders, is the Federalist Society. Now, the Job Creators Network, there's a chain of, shady organizations, right? Think tanks, And so the CRC, which again funds the Job Creators Network, is funded by the Federalist Society. The federal judge presiding over the case is himself vice president and a founding member of what? The Tarrant County Federalist Society. Oops. Pittman is also one of 200 Trump-appointed federal judges, a group that includes nearly as many appeals court judges as Barack Obama appointed in both of his terms. This is why control of the Senate matters. This is why we elect progressive Democrats. Because remember, a lot of Senate Democrats also approved of Donald Trump's judicial picks. Getting Democrats elected is good, but they need to be actual progressives, not corporate Democrats. So let's go to Biden's response, by the way. In a statement, White House Press Secretary Karine Jean-Pierre said this: "We strongly disagree with the district court's ruling on our student debt relief program, and the Department of Justice has filed an appeal. More than 26 million people have applied for loan relief, and the administration will hold on to this information so it can quickly process the relief once we prevail in court. The Education Department, however, is no longer accepting new applications in light of the ruling, but has encouraged borrowers to sign up for updates at studentaid.gov. In a court filing responding to the complaint, the Justice Department argues that the 2003 statute underpinning Biden's plan doesn't require notice or comment. Justice attorneys also argue that the parameters of the program were informed by research that shows the risk of delinquency and default is acute among lower income borrowers and Pell recipients. They said Brown and Taylor were not entitled to any amount of loan forgiveness and that their grievances do not amount to concrete injury." Because again, you have to have standing. And that's been the problem with a lot of the right-wing lawsuits. They just lack standing. But Pittman knew that already. Pittman was prepared for this. He actually told the parties that he had planned ahead of time to rule on the merits of the case instead of determining whether these borrowers had standing to bring the lawsuit. Well, there you go. Now, getting to the other Republican argument about this being unconstitutional, illegal power grab by the executive branch. Now, the HEROES Act in 2003 was passed by Congress. Congress passed it, and that explicitly authorizes in the text that the Secretary of Education is allowed to alleviate the hardship that federal student loan recipients may result as a result of national emergencies. COVID was a national emergency. Therefore, he absolutely had the authority in order to do this. The whole case that they're bringing is bullshit. Neither of these plaintiffs had any standing at all. At all. So it's very obvious what Pittman is trying to do. That's it. Again, there is no good legal argument here. These people are not harmed by other people getting student debt relief that they didn't qualify for. And basically are using or are trying to screw everyone over with the help of these conservative groups in order to deny any win or, I don't really care about, if Biden gets a win, whatever. That's what they care about. But really, they're denying a win for so many student borrowers. Millions of people that are affected by this. It's complete and utter bullshit from an obviously corrupt federal judge.